Hi, my name is Terrence Trujillo, and the IPP I'm doing mine on is on partnerships. Like a marriage, a business partnership often begins with enthusiasm and high expectations, only to end in acrimony or legal proceedings. It's important to know as much as possible about a potential partner, including how his or her finances and family life may affect the business before signing on the dotted line. You should look for a business partner who brings something different to the table than you do. If you're creative, maybe you need a more detail-oriented partner. If you have money to invest in the business, you may want to look for a partner with access to a market or with great connections. Or if you're shy, you might need a good people person to balance the equation. If they're similar to you, it might be more comfortable, but it might not be what you need. It is important to have an understanding of someone's financial status and commitments before getting into a venture together. It is tough to ask what they are currently spending on a house or in payments to, let's say, an ex-spouse. But someone's prior financial commitments shape the decisions they will make in the short term. Partners don't have to spend the same amount of time, but it is equally important that they are on the same page to each other's expected time commitments. How many hours a day does your partner expect to put into the venture? And do his expectations meet yours? It is equally important to level set your partner's expectations on your time commitments. It's important to know what your potential business partner will do if he or she has their back up against the wall, and it will happen. The best way to discover this is to look at what they've done in their past business ventures. If he couldn't meet payroll, for example, did he do the right thing and dip into savings or borrow from a credit card or a friend? Or did he pay employees late or not at all? Or worse, did he skip paying payroll taxes? It all comes down to character issue. Payroll taxes are a federal obligation. If that's negotiable, you can bet your partnership is also negotiable. Establishing percentage of ownership. You should have a record of how much each partner is contributing to the partnership prior to its opening. People have short memories. Typically, these contributions are used as a basis for the ownership percentage, but it does not necessarily have to be. For example, one partner may put in a considerable amount of cash with no plans to work in the business, and a second partner may not invest cash but will provide the sweat equity to make the business a success. As such, the partner who works in the business full-time may get a larger percentage or vice versa. That is up to you. Determine the amount of total investment required to get a business started. Divide your own contribution by the total to estimate a fair percentage of ownership. Use this as a starting point for negotiations with your proposed partners. Discuss your proposed role at the business with other partners. The role you can play at the company and your estimated work contribution may dictate your percentage of ownership just as much as your financial contribution. Finalize your percentage of ownership based on your negotiations with the other proposed owners. Understand that this represents not just ownership, but also the division of profits that the business earns going forward. Drawing up an agreement containing all details of the business arrangement, including each person's percentage of ownership and number of shares. Some websites offer standard agreements for either partnerships or shares in a corporation that you can tailor to your needs, but it is wise to get help of an attorney in this matter. Finally, review the agreement and sign, along with the other partners, in the presence of a notary. Keep a copy of the agreement for your records. Include the same details in your company business plan. In some cases, you must also send a copy of the agreement for filing with your state's Corporation Bureau or Secretary of State's office. Decision-making in partnerships. Making decisions in a business managed by partners is like trying to make decisions in a committee. Nothing really gets done. In fact, they can often stalemate a company, which results in business failure. Therefore, you need to establish a decision-making process in advance so your business operations can move along smoothly. There needs to be a captain of your ship. Under a consensus model, the process of decision-making involves all partners in the business. Each partner has the opportunity to share their opinion on a decision and is tasked with presenting all advantages and disadvantages of the proposed decision. The other partners are encouraged to ask questions to fully understand that partner's position and can raise any issue or concerns with a particular proposal. The consensus process is meant to be a comprehensive approach to decision making, focusing on finding common ground among partners and eventually reaching a collective decision. This does not mean decisions are made unanimously. Business partners agree to live with and support a decision based on open and full discussion surrounding the issue. Making decisions using the democratic process. Making decisions through the democratic process differs from the consensus model in that final decisions on a proposal are made by majority vote. The process leading up to a decision is similar to a consensus. Each partner has an opportunity to ask questions, share concerns, and present alternatives. The democratic model is meant to promote open discussion, but partners are required to vote in one direction or the other. When there are only two partners in a business, outside business advisors or upper management are used to create a balanced voting pool. Making decisions using delegation. In businesses with large numbers of partners, delegation is often used to ensure decisions are made quickly and efficiently. Delegation is the process of deeming certain partners, committees, managers, or long-term employees responsible for making certain decisions on behalf of the company. Some partners have specific skills in marketing or advertising, while other individuals have strong backgrounds in finance. The partnership can utilize these specializations by delegating decision-making in these categories to the appropriate individual. Checks and balances, such as reporting back to other partners soon after a decision is made, can help create a collaborative environment that empowers individuals to take an authoritative role in the business. Delegation is far less time-consuming than the consensus or democratic decision-making models. The bottom line: the consensus and democratic model can take a substantial amount of time, but offer the most opportunity for open discussion and negotiation. The delegation process saves time, but should be implemented within a system of checks and balances to ensure no individual partner takes too much authority in decision making. Resolving disputes in a partnership. What happens if you and your partners reach a point where you can't agree? Do you head to court? Well, only if you want to spend a lot of time and money. My recommendation is to include a mediation clause in your partnership agreement, which will provide a procedure by which you can resolve the major conflicts. Going into business with a partner can be a great way to work. Two heads are often better than one. It is also usually more fun to work with a friend. These types of collaborations are common in many business, particularly professional services firms and startups. Unfortunately, disputes can arise in these situations. They can even arise when a person such as a longtime friend, whom you know very well and trust, a partnership dispute can become one of the most bitter disputes you will ever experience. Fortunately, a partnership dispute can be avoided. However, it requires a reasonable degree of effort up front, a small investment of time and money, and patience throughout the process. There are 5 things you can do to avoid a partnership dispute, potentially resolve one, and above all, prevent from having your partnership damaged. First, make sure you have a written agreement in place. Depending on the type of business involved, this can be either an operating agreement or a partnership agreement. The agreement should, at a minimum, clearly define the following items: who has control and how much, each partner's role, each partner's duties and obligations, capital contributions and what kind, how additional capital contributions will be handled if necessary, compensation and distributions, what procedures the business will adopt and follow for making decisions, and worst-case scenarios such as what happens when there is conflict, the removal of co-founders or partners, whether and when a partner can withdraw, and how ownership percentages change if an existing partner or a new partner invests additional money in the business, and when and under what circumstances the relationship between partners or the business can end or be terminated. If you and your partner cannot see eye to eye and the dispute worsens, you should consider hiring a mediator to help you resolve it. This decision should not be viewed as an admission that you have failed. Rather, it should be perceived as a proactive measure to prevent other, more dire consequences. Many standard operating agreements, in fact, contain a provision requiring that if there is a disagreement regarding a certain set of issues, the partners must hire a mediator to help them resolve those issues. A mediator or neutral individual can assist the partners in several ways. First, a mediator can help both sides present their opinions or positions in non-confrontational ways. This exchange will likely result in a much different and more productive outcome. Second, a mediator can ensure that the partner's emotions are kept out of the discussions. When there is a dispute, emotions are often a major reason why discussions cannot progress or a resolution cannot be reached. Eliminating or tempering one's emotions can help both sides focus on the substantive issues between them. The focus will allow both sides a fair chance to present their opinions and propose solutions. If a resolution cannot be reached in the near future, or if the partners remain in a deadlock, it may indeed be worth considering a separation. For example, if you and your partner do not share the same vision for your business anymore, you should consider terminating the partnership and going your separate ways. Terminating the relationship may be complicated and require a lot of effort and discussion regarding the division of the assets of the business and other items. However, once both sides recognize and accept the situation is unworkable, you might embrace the process of splitting up. Indeed, operating a business where the partners consistently disagree over most decisions will negatively impact your personal relationship, your personal life in general, and the business itself. Sometimes it is better to cut your losses and move on.